The president's claiming, I'm exercising this power within the constraints of the limits Congress has imposed.
Did any president under TWIA use that language to impose tariffs?
Well, yes, President Nixon's 1971 tariffs.
Not a tariff.
Visibly,
that wasn't a tariff. It was a licensing agreement during wartime. It was a specific thing. A tariff, I'm talking.
It was a specific thing. It was a specific, just trust me, bro. Just trust me.
I'm referring to President Nixon's 1971 tariffs.
I'm sorry, excuse me. Yes, I thought you meant Lincoln.
What? What? She thought he meant Lincoln? He clearly said Nixon.
Not only that, but then it was upheld by the Court of Appeals with exclusive jurisdiction under this very phrase.
Can I back you up just a second? I'm sorry. You're talking so quickly.
I don't understand. You're talking too fast for me. This is the first time I've ever thought about these issues. Justice Ketanji, I'm not a biologist. How would I know what a woman is, Jackson? Glad to meet you. What's happening before SCOTUS is really a combination of two separate cases that have been merged. Learning Resources versus Trump is one case, and Trump versus Vos Selections is another case. And they were both percolating through different courts of appeals, and now they both got to the Supreme Court, and the Supreme Court has merged them because they both fundamentally have the same legal issues. And the question for the court is whether the Supreme Court will rule correctly that the democratically elected Article 2 Executive Branch President Donald J. Trump, to whom the Article 1 Congress has delegated emergency tariff powers, whether that president has the authority to leverage those tariffs to address and mitigate the nation's trade and fentanyl and other international emergencies, or will a series of unelected black-robed tyrannical inferior district trial court judges make those calls? Will they happily, those judges, unelected judges, happily accede to the political will of the anti-American progressive fascists in their feckless arguments that American commerce must instead be subject to the manipulation and exploitation by scores of foreign and hostile nations?
I just don't understand this argument. It's not an article. It's a congressional power, not a presidential power to tax. And you want to say tariffs are not taxes, but that's exactly what they are. They're generating money from American citizens, revenue. And you say it's incidental to the regulatory purpose. But I don't see how a quota is equivalent to revenue raising. A quota sets a limit to what you can import in, but it doesn't generate revenue. I don't understand this argument, that it's equivalent, or that foreign powers or even an emergency can do away with the major questions doctrine. Didn't we in the Biden case recently say an emergency can't make clear what's ambiguous?
As to that point, I believe the court has never applied the major questions doctrine in the foreign policy context.
But we
That's
have,
the emergency context, not the foreign policy
counsel,
context.
we have never applied it to foreign affairs, but this is a tariff. This is a tax.
It is a, if I may, it's a foreign-facing regulation of foreign commerce. That's distinct from a tax.
So Biden could have declared a national emergency and global warming and then gotten his student forgiveness to not be a major questions doctrine?
I don't think he could have gotten student loan forgiveness.
Why?
But
It's
perhaps
global.
he could have.
It's foreign-facing. We need all of these things to
This is retarded.
To tax fossil fuel or to do something else. That's all Biden would have had to do with any of his programs?
Let me put it this way, if I may.
Is just declare some foreign-facing purpose?
As usual, Sotomayor asks questions. She asks questions, and then she won't allow the answers.
Maybe I can articulate it this way. The power to impose tariffs is a core application of the power to regulate foreign commerce, which is what the phrase regulate importation in IEPA naturally evokes.
Why
not the
is
power
it,
to tax.
could you tell me why it is that when Congress intended to permit a president to regulate by imposing tariffs, it's always used tariff and regulate? I have about 16 laws in the past that when Congress intended regulate to mean taxing that it used taxes simultaneously.
This
But it
court-
didn't here.
Respectfully, this court came to the opposite conclusion, if I may, in Algonquin, where the phrase was not impose
Well, but
duties
that
of
was, we did something in Algonquin. It was in the duties section, unlike here. It was paired with questions about decreasing tariffs and increasing.
Interrupting is Sotomayor's version of Ketanji Jackson, Brown Jackson's I don't understand. Can you explain?
Of activities that had to do with raising and lowering duties. Here, the verbs that accompany regulate have nothing to do with raising revenues in the form of taxes.
And counsel, Algonquin wasn't a textualist opinion. Do you agree with that? In other words, the analysis that the court was using there was really keyed to the legislative history of that statute, and it wasn't as though we were doing an interpretation of the word adjust.
I disagree with that. I think you read the opinion, first it talks about plain meaning, then it talks about statutory context, and then it goes on to legislative history, so it was all three of those. And the conclusion it came to, it directly addressed and rejected the argument that the D.C. Circuit had accepted in that case, which is that when Congress wants to delegate the authority to tariff, it uses a consistently explicit and well-defined approach, which is to use these magic words, tariff, tax, impost, and so forth.
Well,
The court said, no, Congress is not bound to use that particular formulation when it wants to confer this power.
Let me ask you about the premise of your argument, which you sort of started at the beginning saying that one would expect for Congress to give the president a broad leeway in this kind of foreign affairs context. And I guess I'm wondering whether you also don't have to contend with the actual purpose of IEPA in making this argument, because as I understand it, that the IEPA was designed and intended to limit presidential authority, that Congress was concerned about how presidents had been using the authority under the predecessor statute. And it's pretty clear that Congress was trying to constrain the emergency powers of the president in IEPA. So it seems a little inconsistent to say that we have to interpret a statute that was designed to constrain presidential authority, consistent with an understanding that Congress wanted the president to have essentially unlimited authority.
I disagree with that, because what Congress actually did as—
What part do you disagree with? I'm sorry.
Well, I disagree with the notion that they were trying to constrain the breadth of the action.
So she asks a multi-part question. This would be grounds for an objection in a criminal trial. If you were to ask a witness a multi-part question and then demand a yes or no answer, it's like, well, how am I supposed to answer a multi-part question?
The president may take when it comes to this particularly narrow domain, which is, various regulations of transactions.
But how can you disagree with that? I mean, the history is what it is.
Because they made a series of changes to IEPA that relate to the triggering conditions, so to speak, and the procedures that apply, but they did not change the language.
Right, but what was the intent of Congress in changing the language? Wasn't it to constrain presidential authority in this area?
To constrain it in the triggering conditions and the procedures that apply in this—
So those are the triggering context. The triggering conditions and procedures that apply are a means to constrain. That is how they went around about constraining. But my point is that Congress enacted this legislation with the intent of preventing the president from having unlimited powers in this area. And you're asking us to now interpret that statute consistent with an understanding that—
Nobody is claiming the president has unlimited power in this area. That would be a violation of the non-delegation doctrine. The president's claiming, I'm exercising this power within the constraints of the limits Congress has imposed.
Did any president under TWIA use that language to impose tariffs?
Well, yes, President Nixon's 1971 tariff.
Not a tariff. That wasn't a tariff. It was a licensing agreement during wartime. It was a specific thing. A tariff, I'm talking.
It was a specific thing. It was a specific— just trust me, bro. Just trust me.
I'm referring to President Nixon's 1971 tariff.
I'm sorry. Excuse me. Yes, I thought you meant Lincoln.
What? What? She thought he meant Lincoln? He clearly said Nixon.
Not only that, but then it was upheld by the Court of Appeals with exclusive jurisdiction under this very phrase.
Can I back you up just a second? I'm sorry. You're talking so quickly.
I don't understand. You're talking too fast for me. This is the first time I've ever thought about these issues. Justice Ketanji, I'm not a biologist. How would I know what a woman is, Jackson? Glad to meet you.
Department of Justice defended it as an exercise of TWIA and did so successfully.
What's the significance of the Nixon example and precedent here? Because I think figuring that out is real important to deciding this case correctly. So,
well, there's one obvious, very powerful takeaway from it, which is that this very two-word phrase, regulate importation, that we say it carries with it the authority to tariff, impose regulatory tariffs at the border, forward-facing tariffs at the border, and we say that's a core application of the phrase regulate importation, had been interpreted 2 years before Congress reenacted that language in IEPA, had been interpreted to carry with it the authority to impose tariffs. So this court said in Algonquin, for example, with respect to President Nixon's—
just back on the Nixon, what was the scope of the Nixon tariffs?
10%, he imposed a 10% tariff kind of across the board to all our major trading partners to address a balance of payments deficit, where he was trying to bring all the major industrial nations to the negotiating table, which he successfully did, for the imposition of the tariffs, and they negotiated the Smithsonian Agreement in about 5 months, after which he lifted the tariff. So the tariff there was used, as here, in part as leverage to get our trading partners to the negotiating table, and it was subsequently upheld by the Federal Circuit, the CCPA, its Federal Circuit's predecessor, that had exclusive jurisdiction over that question, to include the power to tariff. And then 2 years later, Congress took that same phrase and reenacted it in IEPA after carefully studying the problem of presidential emergency powers and being deeply concerned about, excessive or abusive exercise of that power. So that whole sort of process gives sort of strong sort of confirmation that this phrase, regulate importation, carries with it the power to tariff. Now, of course, that's not our leading argument. Our lead argument on interpretation is there's a pedigree, historical pedigree of regulating imports specifically, where the power to tariff is just the sort of a core application of that, a quintessential exercise of that power. That goes back to Gibbons against Ogden and Justice Story's treatise, and runs all the way through cases like McGoldrick and Board of Trustees and more.
Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase together, regulate importation, has been used to confer tariff imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's—
Okay, so an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument, that your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power?
Well,
putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's treatise.
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
I think our argument goes a bit further than that as an interpretive matter, because if you look at that history, the history of delegation—
Could you just answer the Justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only two statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA, and then now in IE.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that, but
Yes.
okay.
But then more fundamentally, we rely on the historical sources to show there's this long historical pedigree of broad delegations of the foreign commerce power, not the power to tax that we're not asserting here, delegations of the foreign commerce power to the president, going back to Gibbons against Ogden, all the way through McGoldrick and Board of Trustees, where this court and founding era sources say the power to, in other words, the power to tariff is kind of this natural, as everyone knows, that includes—
Just ask you one other question about the plain text, General Sauer.